Viewers, greetings. In this particular video, we are going to deal with judgments that have come out during the first and second week of July. Of course, the judgments which are going to come out today being Friday, 11th of July, is not has not been taken because it's early morning now. And however, what we are going to deal, there are multiple judgments during this period, and most of them are very important. Furthermore, what we mentioned in the video are just the highlights of the judgment. So I would request the viewers to please peruse the website and go through the judgments, because that will give you an in-depth idea. With this, we move to the next part of the video.
Let us move section-wise. You can see Guide to IBC on your screen. So let us first go to section 7 and deal with two cases. Now in section 7, we are going to topic 128, that's right at the bottom, which says that even if CIRP gets closed by section 12A, there is no impediment in reviving the original or another application for instituting CIRP against the city. This case happened in the case of Transcon Sky City Private Limited versus Anchor Point Developers. Now, in this case, what happened? There was a settlement. But there was not a settlement. In fact, there was a Section 7 moved, and there was a settlement also. But post-settlement, what happened was the corporate debtor failed to honor the settlement agreement. But at the time when the settlement took place, though the settlement agreement was placed before the adjudicating authority did not mention it in the order. So at the time when the corporate debtor failed for the second time, the financial creditor moved again, and he moved the NCLT. In fact, went in for reviving the original CP, company petition. So the main objection was how the NCLT could revive the original CP. The NCLAT held that adjudicating authority has therefore been very fair and reasonable in giving liberty to the appellant to contest the revival of first CP, thereby protecting the interests of the corporate debtor. While allowing the NCLT had allowed the respondent, that's the corporate debtor, to object to it. So he had no ground to complain on that account. So let us now go to another case that is in topic 95, if I'm not wrong. This is a very nice case. Punit Risutra versus Jammu Kashmir Bank. The main heading is under Section 128 of Indian Contract Act 1872. The liability of the guarantor is coextensive with that of the principal debtor. But the coextensive nature does not imply automatic release of one upon the settlement with the other. So in this case, what happened was there was a corporate debtor. The corporate debtor had availed loan from Jammu Kashmir Bank. Jammu Kashmir Bank, the corporate debtor approached the Jammu Kashmir Bank with ODS proposal, but then they arranged to sell a plot of land and get into an agreement with its guarantors. And the guarantors went ahead with an ODS proposal of 11 crores or something, 11.3 crores, which they paid to the bank. Bank accepted it and released the personal guarantors. But they retained the right against the corporate debtor. They wanted another 4 crores odd. And they moved a Section 7 petition. And before that, they had also moved into SARFAC also. So the court held that the application was filed within 2 years and 9 months, therefore squarely within the 3-year period of Article 137 of Limitation Act, and also that upon under Section 128 of Indian Contract Act 1872, the liability of the guarantor is coextensive with that of the principal debtor. But the coextensive nature does not imply automatic release of one upon the settlement with the other. Now let us move to the case in Section 10A. There is no provision under Section 10A of IBC that prohibits parties from entering a valid debt restructuring arrangement during or after the Section 10A suspension period. This is the case of Gangadhar Kotian versus Catalyst Trustship Limited. In this case, what happened was there was the corporate debtor had availed debt from the financial creditor, but the default occurred during the COVID-19 period. So under suo motu order of Supreme Court, the 10A period, the Section 7 was rejected. Under Section 10A, petition was rejected. But thereafter, the financial creditor and the corporate debtor, they entered into a restructuring agreement in which superseded all other correspondences which were made earlier. And the debt was payable on sometime in 2023. And they moved a petition under Section 7. And it was fully allowed because there was no impediment. Because the default, the second case was a result of a fresh cause of action. So court held the Section 7 petition was it could fully be maintained because there is no provision in Section 10A of IBC that prohibits parties from entering a valid restructuring arrangement during or after the Section 10A suspension period. Now let us go to this is by far the most important case. Five eight, that is financial debt. Topic 34. This was Moneywise Financial Services Private Limited versus Mr. Arunabu Shikdar, RP. A guarantee, unless invoked, does not become a debt. Now, in this case, a financial creditor had moved a petition against the corporate guarantor. So the court, but could not place the corporate guarantee. He placed various agreements, but the corporate guarantee could not be placed. So the court held that until and unless the corporate guarantee is invoked, the debt does not arise. There is one very important aspect also, which which will have a long time effect. Let us go to Section 12, Regulation 12. Court held that claims filed at a belated state of CIRP cannot be accepted, and that would derail the entire CIRP process. And they held that belated debt are not accepted because they also are barred under limitation. But what was most importantly held was that simultaneous and overlapping claims are not permissible unless recovery in one CIRP is proportionately adjusted in the other. That is, if a bank or a financial institution has given a debt to somebody and another company or somebody has given a corporate guarantee. You cannot put both claim in the case of the principal borrower and the corporate grantor the same amount. Because in case of recovery, it will lead to unnecessary, unjust and enrichment. Even where a guarantee exists, the claim can be rejected if the right to enforce it has not crystallized, or if admitting it would result in unjust enrichment or procedural abuse. Court in this case referred to a judgment in the case of Piramal Capital Housing Finance Limited versus Hydric Infrastructure Private Limited of NCLAT, and held that this is not permissible. So this is a very important aspect, and we insolvency professionals often come through this. This possibly came out in last Friday. That is last Friday, and this is going to have tremendous implication, and which we should always know. Now, let us move to straight away move to Section 238. Also, this will have effect in Section 14 and so, but since we have a time constraint, so let us move to Section 238. Section 14, 238, topic 24. This is a deadly topic. NCLT is not empowered to deal with matters falling under the purview of another authority under PMLA. This was held in the case of Mr. Anil Kohli versus Directorate of Enforcement. In this case, the NCLAT referred to Bhushan Steel judgment and said, and opined, there's a long judgment, opined that NCLT does not have jurisdiction. Two, because PMLA and IBC are their objectives are completely different. They are not conflicting with each other. So, one is for public, one is for violation of public interest or public property. This is for company revival. So they don't really contradict each other. So in such case, NCLT cannot possibly intervene in the progress. IBC and PMLA, though occasionally intersecting, are not inherently inconsistent. But at the same time, I would like you to, since this is a case, and this referred to Kalyani Transco versus Bhushan Steel, so it is better to look at another aspect. This was, and said that Section 14 moratorium also is not applicable. Now let us go to topic 23. But this was in the case of Government of Tamil Nadu versus N. Ramachandran. A statutory authority having raised its claim cannot simultaneously press upon the recovery of tax dues by continuance of attachment of the assets of the corporate debtor. Now, in this case, of course, we have seen that GST authority, there is usually, it says that with the exception of IBC, but herein, the court did not move in that line. They said that what was the purpose of attachment? The purpose of attachment was to recover money. And GST authority was a claimant. So if the attachment is, the liquidator is not allowed to sell the property, then how will the GST department recover the money? So removing the attachment is beneficial for the government, for the GST authority also. So in such case, the government should be, the IBC should be allowed to prevail over GST or prevail over prevail over the Money Recovery Act or whatever the Revenue Recovery Act. So we have just now dealt with the case of uh, of Anil Kohli, in which NCLT said that PMLA and IBC does not prevail over PMLA. And now we are dealing with the case of government of Tamil Nadu, in which it said that PMLA cannot be, IBC does not prevail over PMLA. But what if PMLA, the report on the ED is moving as per the direction or as per the complaint lodged by the bank or the financial institution? So what is the objective of the financial institution? To recover the money. If it is moving because of something else, then it is different. But then, if in the case of it is moving according to complaint lodged by a bank or financial institution, then in my opinion, of course, I may be wrong, but then in such case, this government of Tamil Nadu will apply. That is my opinion, and I'm not an adjudicating authority. But I think this is a way out. And in multiple cases, like in there has been Supreme Court has held that has held that in other cases that IBC will prevail over PMLA. And for the first time in Kalyani Transco, the judgment was that that IBC cannot prevail over PMLA, and this is a new judgment issued by NCLAT. So there is a question. Earlier we had the question of limitation, which Supreme Court took its time, but ultimately it got resolved. Now this too will get resolved, but we have to allow a reasonable time for it, for the judiciary to come to a definite conclusion. Now let us come to an interesting case in Section 31 and Regulation 38 also. This is the case of Univastu India Limited versus Setubandhan Infrastructure Limited, wherein the main takeaway is the adjudicating authority needs to delve into depths of a resolution plan to assert violation of Regulation 38. In this case, what happened was adjudicating authority rejected a resolution plan, stating that there were various violations of Section 38 and also subsection 2 of Section 30. So NCLAT went into deep and they delved deep into the depths of this particular resolution plan, and they found that the adjudicating authority had erred in adjudicating various points. And they said they ultimately came to the conclusion that there was no violation of Regulation 38. Furthermore, they came to a very valid point, which is there in topic 108, Univastu Limited versus Setubandhan. When COC has approved a resolution plan by requisite vote share, after considering its feasibility and viability, such decision of COC cannot be interfered in the exercise of judicial review. We often face, I have faced, NCLAT asks whether the COC has approved, has considered the feasibility and viability of a plan. Obviously, when a COC approves a plan, they will only approve if it is feasible and viable. So whether it is specifically mentioned in the resolution or not, resolution plan or not, or in the COC minutes, fact remains that it has been seen and it has been observed by COC. Otherwise, a plan cannot be approved. So NCLT, adjudicating authority, cannot interfere and exercise judicial review to find whether COC had considered the feasibility and viability of a resolution plan. Furthermore, there's a very important aspect in this particular case, which says that in this case, three values were put for as a resolution amount because it depended on contingencies. So this also clears a myth that there has to be a definite resolution amount. It can be different. It can be different. I mean, they can consider contingencies and mention because of if this realization takes place, then this will be the amount. If the Y realization takes place, then that will be the amount. There's nothing wrong in that. So this is an important case. It's a huge case. You should go through it. Now let us quickly move to another case in section 31. Yeah. This is topic 107. Now, this is in the case of Girish Sriram Juneja versus Soneco Marketing. This has relation to Indian Sugar, Supreme Court judgment. The main headline is in CIRP, the main objective is attaining a resolution plan. Thus, adjudicating authority should proceed to consider the application for approval of resolution plan instead of diverting to other things. Now, in this particular case, what happened was there was a question, there was an intervention petition in which they wanted removal of RP. And there was a difference of opinion between the member judicial and member technical. Whereas in independent sugars, Supreme Court had issued direction that within following days, the resolution plan should be approved. The judicial member recused himself also from this case. So NCLAT came, requested the president of NCLT to look into the matter and held that the question of RP being eligible or not, that is not so much important. The importance is approving resolution plan. And that the adjudicating authority had been wasting time in, I'm sorry, I should not use the wasting time word, had diverted to some other topic. It also helped, which you will find in Regulation 3, it's in Section 16, in Regulation 3, that existing assignment shall not get affected by expiry of authorization of assignment, that is AFA. So, this also, it has been held by various high courts also, but this is an NCLAT judgment that expiry of AFA does not, it says that expiry of, in the event of expiry of AFA, an insolvency professional cannot take up any new assignment. But the assignment which is continuing, he can continue with that. There is no impediment. Now, we have covered this, so let us come to another important aspect. Let us straight away move to section 331. Security interest. Topic 108. Topic 3, oh, I'm so sorry. Now, it says that security interest by creditors can also be proved if the same is available at CER's SAI and not completely and exclusively dependent on charge registered with ROC under Section 77 of Companies Act 2013. This was held in the case of Bizloan Private Limited versus Mr. Amit Chandrasekhar Pundar. Now, what is CRSAI? It is the Central Registry of Securitization, Asset Reconstruction and Security Interest of India, CRSAI. This is a body created by government, essentially applies to banks and ARCs, where they register all the loan documents and charge creations. So after much deliberation, NCLAT went into various aspects of Companies Act, various aspects of other laws, provincial insolvency law and other things, and came to the conclusion that yes, as per law, registration you have to create a charge under Section 77 of Companies Act. But in the event that a charge is registered in CRSAI and not at under Section 77 of Companies Act, in that case also the creditor will be considered as a secured creditor. Now, this is for the first time it has been held, and as such, I need not emphasize the importance of this. Now, let us go to Section 66. This was held in the case of Mr. Gopal Kalra versus Akhilesh Kumar Gupta. NCLAT held what? Courts are not required to have direct proof of criminal intent. Courts are not required to have direct proof of criminal intent. Circumstantial evidence under which, when sufficiently compelling, can justify the finding of fraudulent trading. NCLT or NCLAT are not CBI, are not Directorate of Enforcement. Then what they need is circumstantial evidence, compelling circumstances which are sufficiently compelling. The court can infer that there has been fraudulent trading. But court also simultaneously held that yes, only based on circumstantial evidence, court can infer that there has been fraudulent trading. But at the time of imposing cost or penalty, there has to be a definite formula. There has to be. That cannot be based on estimation. There has to be a definite reason behind it. And it has to be calculated based on a particular formula, which has to be, which one can easily understand. So in this case, this is a very important case in which the promoter suggested, he stated that he had diverted into business of LED lamps, and there were many dealings which were not proper, and court found that there was a forensic audit, and based on which court held that yes, there are fraudulent trading. But court exactly calculated what is the loss to the corporate debtor. And that exactly is the amount which they claim, which they ask the corporate debtor or the promoter to pay. So what we understand is that circumstantial evidence is good enough. But when you are when we are ordering a cost to be paid, there has to be a definite formula. Now we come to the last part of the judgment, our last part of this video, and let us go to Section 138, which deals with discharge order. This was held in the case of Mr. Anil Sial versus Ajay Gupta and others. The court categorically held that Section 138 cast an obligation on the bankruptcy trustee to apply for discharge on the expiry of 1 year from the bankruptcy commencement date. So, herein what happened was the bank had not, all the properties of the bankrupt had not been sold. But yet, and the bankrupt had moved to the court. Court held that the bankrupt has a locus. Bankrupt has a locus to request the court to consider his discharge. And it is the bankruptcy trustee cannot take the alibi that the committee of creditor was not approving. It is his duty to apply for discharge order on expiry of 1 year, or once the administration of bankruptcy assets are over, whichever being earlier. So with this, we move to the next part of the video.
We have come to the conclusion of this video. Hope you enjoyed it. Looking forward to see you next week. Thank you.